The next topic I'm going to speak about with you is the issue of maintenance between spouses. I'm not going to deal with children's maintenance at this stage, but just between the spouses themselves. And I'm going to break this down into two separate videos because it's quite a lot of content. The first one is going to be relating to maintenance pending the finalization of the divorce, and the second will be maintenance post the divorce. So very often when clients come to me, when they want to institute divorce proceedings, they also have a need for maintenance pending the finalization of the divorce because they are either earning less than their spouse or not earning any income at all, but they need to be able to survive pending the divorce happening and pending them being paid out any patrimonial consequences from the divorce, which I dealt with in the previous video. So there is a very specific procedure to follow, depending on which court you're out of. If it's the High Court, it's called a Rule 43 application. If it's the lower court, it's called a Rule 58 application. For the purposes of this video, I'm just going to refer to it as a Rule 43 application, but the procedures are the same, the rules are the same, just different rule numbers depending on which court you're out of. I want to start by telling you that as soon as you get married to somebody, there is an automatic, what we call a reciprocal duty of support. So this means that both spouses are obliged by law to maintain one another. So for example, if one of you were to stop working in order to raise a family, or you were to lose your job, your spouse has a legal duty to maintain you. This duty of support continues until you get divorced. Now, in the next video, I will talk about post-divorce maintenance because it is possible under certain circumstances. But for now, I'm going to talk about just the maintenance that you need pending the divorce. So if you were to come to go to an attorney and say you need maintenance pending the divorce, the procedure is as follows. You, as the applicant, will file what's called a sworn statement, which is a short affidavit setting out what your maintenance needs are, why you need them, how much you need, and why the respondent, which is your spouse, is liable and able to pay. So the very first thing that you need to do is you need to establish how much maintenance you need. Now, maintenance covers a whole host of things. So there's a schedule that you complete that sets out all the different things expenses that you may need covered. So for example, it could be a bond or rent, rates, utilities, groceries, insurance, motor vehicle or transport expenses, educational expenses if you happen to still be studying, clothing, let's see what else, medical expenses, pet expenses. So all of these type of things, basically any monthly expense that you may have is an expense that you can essentially claim from your spouse if they were paying those expenses or are in a position to pay those expenses. Now, the expenses that you claim must be accurate and realistic and reasonable. You can't, for example, claim 50,000 Rand a month groceries for one person if your grocery bill for your entire household was 5,000 Rand, because the court's going to say that that is unreasonable and lavish or luxurious. You are claiming for maintenance, which is what you need in order to continue to live more or less at the standard to which you have become accustomed. Now, the difficulty that a court is faced with is that there was one household with an income. Now, let's say only your spouse was working and you were not working. So there was one income that was supporting one household. Now, all of a sudden, you've still got one income, but you've got two households. So the court has to be alive to that fact and will therefore, when it is making an order in terms of Rule 43, it will make an order based on what is affordable and reasonable. So the courts have held, for example, that the court can't give an order for more than what the respondent spouse is actually earning, because it makes the order impossible. So when you bring the application, you're going to file an affidavit called a sworn statement. That affidavit has to be short. So we usually limit it to 20 to maximum 25 pages, absolutely maximum. And unless the matter is incredibly complicated and there are a lot of businesses involved or that type of thing, you need to keep it as short as possible. You then, in your statement, you can have annexes attached to that, but again, you need to limit them as much as possible. But you need to be very clear and very accurate on what it is, number one, that you need, number two, why you need it, and number three, why the respondent should and can pay. So, for example, let's say you are staying in the matrimonial home and the bond and the utilities and the water and lights and the insurance have always been paid by your spouse. You set that out, you set out what those amounts are if you know them, and you say that you want an order directing the respondent spouse to continue to pay those amounts. Then you may have a motor car and your spouse has always paid the monthly finance on that motor car, the insurance on the motor car, and replacement of tires and maintenance and licensing fees for that car. Then you will again set out that your spouse has always paid those amounts and you want an order directing your spouse to continue to pay those amounts. Then you have expenses that don't necessarily fall under specific expenses like those, which are, for example, clothing, shoes, your personal care, like going to the hairdresser or the barber, or groceries, those type of things. For those sort of things, you're going to need to provide some form of evidence as to what you were spending on a monthly basis and then what your needs are. So, for example, you might have been just you and your spouse, and your groceries every month were 10,000 Rand a month, and you would go out to dinner twice a month, and that would cost you 1,000 Rand. So you take those expenses and you basically cut them in half and say you now need X amount of money per month for those specific things. You can include things like entertainment if you were eating out or going to movies or that sort of thing on a fairly regular basis. And if you did a lot of traveling, whether that was international travel or local travel, you can also claim an amount so that you can continue to travel if that is what you want to do. But again, it needs to be something that it's reasonable in the circumstances. It is something that your spouse has historically paid, and it is something that your spouse is in a position to continue paying. So just like your spouse now will also have expenses that he or she is going to need to continue to pay for themselves as well as now for you. And that always has to be borne in mind. And so the court takes a very robust look at what it is that the applicant's needs actually are, and what he or she can survive on and what he or she has in order to survive on that. Now, what you do need to say to the court is, these are my assets, this is what I do have, and for example, you might have investments or savings or that type of thing, which if you show that to the court might say, well, you're actually capable of maintaining yourself because you have R1 million in the savings account, or you have R500,000 in an investment account, so you actually don't need maintenance from your spouse. Or conversely, your spouse may have, be earning a limited income, but may have a lot of assets that are easily liquidated, such as investments or savings, that can be then used to pay maintenance for you. So these are all the types of things you need to consider. Remember in the first video, I spoke to you about that financial disclosure form that's in the Gauteng division now has to be completed by both spouses in a divorce proceeding. In a Rule 43 application, that is a very handy document because that document, the spouses are required to set out all their assets, all their liabilities, and then their income and expenditure. And that is done on affidavit, as I said earlier in the previous video. So it has to be very accurate and the truth. So that can help you if you're needing to bring a Rule 43, or if you're opposing a Rule 43, so you're the respondent spouse, and for example, you want to show that certain of the expenses are unreasonable, or you never paid them before, or they're just luxurious expenses, you could use that financial disclosure form to assist you with that. Once you have drafted your sworn statement, if you're the applicant, you have a notice of motion that sets out exactly what it is that you are wanting the order that you want in the court to make. That gets served on the respondent spouse, and that spouse then has 10 days to file a sworn reply, which is essentially like answering affidavits in a normal application proceedings, but you don't get an opportunity as the applicant to respond to that affidavit. So that is why in your founding affidavit, in your sworn statement, you need to make sure that everything in there is 100% accurate. Because if you leave anything out, or you don't tell the court that you've got a savings account or something like that, and then your spouse in their reply says, oh, but my spouse has got R1 million in savings, or whatever the case may be, and is able to support themselves, the court's going to look at that and say, well, you didn't come to court with clean hands, so therefore the court may not want you to order. So just make sure that you are very clear in what you have, what you do have by way of assets and income to support yourself, and why it is that you don't have enough to support yourself and need the support of your spouse to assist you. I think I have covered everything in regards to this. These applications take 2 to 3 months to be finalized, and then you will get an order. Oh, one of the other things that I just wanted to add in is that you can also, as the applicant, ask for a contribution towards your legal fees. Now, you have to set out a schedule of how you come to the amount that you're asking for, and this amount varies dramatically depending on the circumstances of the parties. If it is not a complicated matter, you may get 15,000 Rand, you may get 40,000 Rand. If it is a very complicated matter and there are businesses that need to be valued and assets that need to be found, and there's the possibility that assets are being hidden, or there's trusts and things like that, then you could get way, way more than that. There have been judgments where those amounts have reached, close to R1 million. But like I say, those are very complicated matters where the legal fees are going to be excessively high and the trial's going to take a long time and those sort of things. And you want to hope that that's not going to be the situation with your matter. But that is the situation with regards to maintenance pending the divorce. Or one last point that I'm not sure that I covered right in the beginning. You can only bring a Rule 43 application or a Rule 58 application in the regional court if divorce proceedings have already been instituted. So you can launch both at the same time. So you can have the summons issued and the Rule 43 application issued at the same time. That is acceptable, provided they both served at the same time. But you can't serve a Rule 43 application unless a summons has already been served or is served at the same time. So just bear that in mind when it comes to that situation.